So there are a lot of provisions that landlords put into their leases that are perfectly okay and legal. But then again, there are a couple of things that the Nebraska Landlord Tenant Statute strictly prohibits a landlord from including in their lease agreement. And that's what we're going to talk about today. Hey everyone, if we're meeting for the first time, my name is Vojchehoske and welcome to Nebraska Landlords YouTube channel, where my mission is simple, and that's to enhance the landlord-tenant relationship through education. So we're continuing our series, breaking down the Nebraska Landlord Tenant Statutes. Today we're going to discuss Nebraska Revised Statute 76-14-15, which deals with prohibited provisions in rental agreements. So landlords include many different provisions in their lease agreements. For example, they're going to outline whose responsibility it is to shovel the snow or to mow the lawn, where you place the trash, prohibitions on what you can and can't do with the house as far as painting and decorations and what type of cars and vehicles can be parked on the property, etc. But there are a couple of provisions that are expressly written into the Landlord Tenant Act that landlords cannot include in their lease agreement. And I have them on your screen here. And basically, Nebraska Revised Statute 76-14-15 says that a landlord cannot require a tenant or put a provision into the lease agreement that requires the tenant to waive or forego a right or a remedy under the Nebraska Landlord Tenant Act. Probably the most common that I see under this provision is I will see a landlord put language in their lease agreement that says that if a tenant is late on their rent, that they agree to forego the entire restitution and eviction process, and the tenant gives the landlord permission to simply change the locks and they're locked out and forfeit their security deposits. That's probably the most common that I see. Landlords, you cannot include provisions in the lease agreement that basically requires them to waive their rights that they have under the Nebraska Landlord Tenant Statute. Now, one other provision that's prohibited is a landlord cannot require a tenant to accept responsibilities for claims arising out of a breach of the lease agreement or the landlord-tenant relationship. So, for example, let's say a landlord could not put a provision in the lease agreement that says that if I'm ever, found guilty of a fair housing complaint, then you agree to pay that. All right, that would be an example of bullet point number 2. Bullet point number 3, a landlord cannot put any language in their lease agreement that requires the tenant to pay the landlord's attorney's fees, no matter what. Now, an attorney can go into court and ask the judge that the tenant pay the landlord's attorney's fees, and then the judge is going to make a determination based on the case's merits. But it's not automatic, and you can't make it automatic as a landlord by putting that language into the lease agreement. All right, so what happens if the landlord does include one of these prohibited provisions in the lease agreement? Well, number 1, that specific provision of the lease is unenforceable. Number 2, what can happen is, depending on how many of these prohibited provisions are in the lease and the judge that you draw, the judge could throw out the entire lease as unconscionable. They call that unconscionability. The other thing is that if the judge determines that the landlord's actions by including those provisions in the lease agreement were deliberate, then the tenant can sue for actual damages plus attorney's fees. And stay informed. It's so important to stay informed. And how do you do that? Check out this video right here. Don't forget to subscribe. Click the little circle to my left. That's all I got. See you in the next informative video. Thanks, everybody.